Stanford University.
Welcome. I'm Liz Magill. I'm the Dean of the Law School, and I'm delighted to see you this afternoon. I know we're competing with some extraordinary weather, although we are not competing with a World Series game, so we will make sure to finish before that game. I'm going to introduce the panelists and moderator today, and we're just delighted to have this collection of people who have so much to say on this topic, and I suspect so much to say that will not always be in agreement, which is always fun with a panel. So let me first introduce Leonard Aragon. Leonard is a Stanford Law School graduate from the class of 2001. He's currently a partner at Hagens, Berman, and is a top litigator in several of the cases you have read about involving athletes, video games, and licensing. Let me next introduce Debra Zumwalt. Debra is the Vice President and General Counsel of Stanford University. She's responsible for the legal work of the university, the hospitals, and its clinics, including the Packard Children's Hospital. She's had this role since 2000, and she received her JD from the law school here in 1979. Elsa Cole is currently the University Counsel at the University of New Mexico. In her previous life, she was the General Counsel and Vice President for Legal Affairs for the NCAA, and she held that job for 13 years. During that time, she worked on the passage of regulations aimed at creating meaningful educational experiences for student athletes and better safety equipment and guidance for them, as well as ensuring the implementation of Title IX gender equity in NCAA programs. Elsa is a graduate of Stanford. She graduated in 1971. We also have, next to Elsa, Michael Gosling. Michael was a pitcher for the Stanford Baseball team from 1998 to 2001. He graduated with a degree in human biology. He was then drafted by the Arizona Diamondbacks and played in the major league and minor leagues until 2010. He returned to Stanford in 2012, and he's currently a student at the law school. We will have joining us very shortly Mr. Bernard Muir. He will just come down these steps and come up and sit in his chair between Debra and Elsa. Bernard was named Stanford's Jaquish and Kenninger Director of Athletics in 2012. He brings nearly 25 years of experience of athletic administration, including roles at Delaware, Georgetown, Notre Dame, Butler, Auburn, and the NCAA itself. He was a college athlete himself, playing basketball at Brown University. We're also grateful that we have on this panel a wonderful moderator, Professor Bill Gould of the law school. Bill joined the law school faculty in 1972. He's the Charles Beardsley Professor of Law Emeritus. He's a prolific scholar of labor and anti-discrimination law and has been a very influential voice, especially in worker management relations, including in baseball, including in professional sports, for more than 40 years. He served as the chairman of the National Labor Relations Board from 1994 to 1998, and during this time, the agency played a crucial role in ending the longest baseball strike in the history of the game. So please join me in welcoming our panelists. I'm handing it over to you, Bill.
Okay, thanks, Dean. It's really a pleasure to be here and to be in such august company, and also to be with two of my former students, Mike, whom I watched just dazzle the hitters with his left-handed repertoire on the field for Stanford, and Leonard. Both of them were in my sports law seminar. When the sports law seminar began, long before they were participants in it, I feel as though we were talking about many subjects that, although I know Debra will take deep exception to this, were deja vu, all which make us think of today, deja vu all over again, because 40 years ago, there was a question of whether or not professional players, overt professional players, would have some kind of representation, and these issues, like the ones today, were fought out under the rubric of labor law and antitrust law. There are a number of things going on today that I think kind of kick off our discussion. The head coach at Alabama makes $6.9 million a year. The average head coach in Division I is about a mere 1.5. Ohio State football team moved into a $2.5 million, 10,000 square locker room facility, and the coach received a very nice bonus when one of his wrestlers, the head of the athletic department, when one of his wrestlers won a big tournament. Florida State and Auburn qualified for last year's Bowl Championship Series, bringing in their conferences each receiving $18 million. And so it is. Recruiters flying frequently on private planes, athletes train on top-of-the-line equipment, and teams compete in mammoth stadiums, athletic budgets frequently going to 60,000 a year, 60 million a year. So there's a lot going on, and these kinds of things, perhaps as much as any others, have fueled labor law. You saw in the opening clip about the Northwestern players, antitrust litigation. Leonard and I were just speaking about some of the cases that he's involved in. Indeed, as he pointed out to me off stage, now minimum wage litigation. So we've got a great panel to talk about the old rules and the new ones, where the power conferences now are increasing the amount of money that will go to players responding to some of these reforms. So I'm going to turn to the panel to talk a little bit about what they'd like to talk about, and we'll take it from there. Maybe we'll go left to right. Mike, do you want to start off?
Yeah, so I'm honored to be here to speak and provide a perspective of a fairly recent student athlete, and also somebody who has been in the professional ranks and understands the difference between what college sports are and what professional sports are, or at least how we expect there to be differences. And to just talk a little bit about how I think the prospect of paying players in kind of the big two sports, football and basketball, might trickle down to affect a lot of other sports and even potentially affect high school players and affect recruiting. I don't have the legal expertise that a lot of these panelists do, so if you have really hard legal questions, please direct them elsewhere. I have enough tests and finals at school right now, so they can have those. But I'd like to just talk about a little bit about how some of the smaller sports will be affected, and just kind of the general vibe that I think, what it is now and how it could change if basketball and football in particular become kind of pay-for-play sports and become a little bit separate from the other sports in a college program.
My turn. Well, hello everyone. My name is Elsa Kircher-Cole. I'm looking around the audience trying to see if anybody is here I know from my class of 71 who just might have wandered in or be part of all of you. But anyway, I did spend 13 years at the NCAA as its general counsel. Before that, I was general counsel at the University of Michigan. Before that, on the legal staff at the University of Washington for a number of years. So I have the perspective of also being both on the campus and working at a national organization that's trying to deal with some of these very complicated issues. And now I'm back on a campus at the University of New Mexico, so I have a variety of different perspectives from those years to share with you. I think for those who are not familiar with the fact that it's really the member schools who make the rules at the NCAA. It's not a group of folks now in Indianapolis who decide what the rules should be about this. It's each of the schools that are a member have an opportunity to participate in a voting arrangement that's too complicated to explain right now, but it is a participatory democracy. So understanding the conflicts that you have when you have a great deal of money coming now into the sports has complicated a situation that already existed ever since the NCAA was created back in 1906. There have been strains on it regarding those who really want to have athletics be an integral part of higher education experience and those who want to profit from it. And with the advent of all the television opportunities that exist now, the money being as big as it has simply made it such a more difficult situation for the students and the coaches. The disparity of the money has, as was just explained by a moment ago, has been so great now that it really is a grabber, and student athletes are saying, where's my share? So having had to defend against many of these lawsuits when I was there, I'll be talking about the perspective of that as we go forward.
And I'm Bernard Muir. I apologize for being late, but as any good athletic director, I'm working up a great sweat. And I would just say, starting my junior year, if you will, here at Stanford, it's been a wonderful experience. But this is the fourth time today I'm going to get to talk about the issues that we're faced with in intercollegiate athletics, especially the pressures and the demands, not only on our student athletes, the time demands, the ability to balance both the academic and the athletic at the highest level here at Stanford is quite a challenge in itself. And then now to couple that with discussion about potential unionization or deeming student athletes as employees makes us greatly concerned, especially, as you can imagine, here within the community. There's been an article that was recently released by the Alumni magazine. Hopefully many of you have read it. It was really to get the Stanford community to start thinking about the issues at hand and how this could affect us. And all in all, I think from our board of trustees to our president to our provost to our faculty, I think everyone would deem that this is an educational enterprise. The opportunity to come compete at the highest level, get a quality education is first and foremost. And I worry about all the other conversations that are leaning toward the professionalism of intercollegiate athletics, and that's not the direction we want to head in. So I look forward to the conversation and continue to move forward from there.
Okay. Well, so I'm Debra, and then Mike disclaimed deep knowledge of the law. I disclaim deep experience in athletics. When I was young, my main contribution on any of the few teams I was on is that I knew the rules better probably than the coaches and umpires. So I could always argue the point, but I wasn't so good in performing. I've been a lawyer for a long time. I'm class of '79, and practiced in doing litigation in a big firm. And I represented Stanford in connection with a challenge brought to the NCAA drug testing program back in the late 80s, 1980s. And that was a really interesting case and really got me thinking about many of the legal issues that are involved in athletics. And then I've been the general counsel at Stanford since 2000, and it's been in the last few years where I've been spending a lot more time thinking about the law as it relates to athletics. It's, as we've mentioned, not only all these legal issues that are arising from litigation, but also there's proposed legislation. There's been legislation in California. There's other legislation that's been proposed both on the state and federal level. So right now we're really, in my view, facing assault from a number of different sources based on the fact that I think there are some bad actors and bad situations in college athletics, and so people want to deal with those things, and I think, in my view, not properly looking at the universe as a whole and saying, where do we want to go, where do we want to be, and what's right for college athletics. And no surprise, I'm a firm believer in the student-athlete model, and that the students really are athletes, and that college athletics is different than professional sports, and we should do everything we can to maintain that difference.
Hi, I'm Leonard Aragon. I filed most of the cases that Elsa defends.
Defended.
They
are no longer my problem. Every now and then I read about one, I go, oh, not my problem. Go ahead.
Well, when we first filed the very first case a long time ago, we didn't realize that it was going to become a series of other cases, but it was like a little nesting doll of wrongs that the NCAA has done against students. So one case begat another case, begat another case. So I have a hand in everything from concussions to grant and aid to the multi-year scholarship case to the right of publicity case. And I don't see, and my law firm doesn't see itself as, I'm not sure, I thought about this a lot, team market or team reform. For us, there were a lot of wrongs, and we tried to correct those wrongs. And I think I too believe in the student-athlete model. I think the big problem from my perspective is the student athlete amateurism model is an amateurism model only for the student athlete and no one else. And I think that's the basis of our lawsuits, in that we need to change that model and make it more fair for the student athletes, and realize that college athletes is a professional endeavor, at least in some aspects.
Well, this idea of team reform against team market really is the first of the themes that we want to pursue with our panelists. Joe Nocera, the columnist for the New York Times, so far as I'm aware, came up with this idea. Well, the team market, meaning let every player be able to go out there on the market and do the best he can for himself or herself. Team reform, meaning we've got the student athlete framework. Let's see if there are inequities in it that should be reformed. That's what's generated so much of the litigation. Even in the professional sports themselves, of course, we don't have team market in a pristine, pure sense, because, of course, they all limit, for instance, player mobility. They limit, they don't allow any player who's drafted, like Mike, to immediately come along and bargain with some other team the year after he's drafted. There are constraints. And so also there may be constraints here. Now, one of our panelists, Bernard Muir, was a witness in the O'Bannon case involving the question of whether college players can share the revenues that are obtained for the use of their images. He had a good deal to say testimony-wise in that case. We talked briefly on the telephone about it a week or so ago, and the judge quoted his testimony in a number of instances. And so I guess really when we look at the antitrust attack on some of the practices that are being engaged in, we should turn to Bernard first, because he's really been right in the trenches on this.
Certainly, it has been a difficult conversation to have now that we've gotten the judge's ruling. Now many athletic directors are trying to figure out, okay, how do we handle this? What's to come? And certainly it's a difficult conversation we're having even in our own circles here as to how far do we go. I think the cost of attendance measure, which will probably be passed in January when the NCAA convention occurs, is something that we're all geared up and ready to afford our student athletes that opportunity. For us, that's probably another $1.2 million to the budget we factored in. But then when we talk about this trust fund, that's a little bit a different conversation that I think we'll have within the community as to how far do we go. And I think the pressure will certainly mount. People will want to get to that $5,000 cap rather quickly. And we'll have to figure out how close is this right for the Stanford community, and obviously other schools will have further discussion about this as well.
Now, Judge Wilkins, in her opinion, said that there ought to be a cap on the amount that college players would be able to obtain from the use of their images, and $5,000 was the cap that she came up with. All of this, of course, is on appeal now to the Court of Appeals for the Ninth Circuit. How much is right, Bernard, and what would you say about that?
Well, I think first and foremost, when we look at the resources we're providing to the student athlete, again, looking at the lens through the Stanford community, when I think about a full cost of attendance, when I think about the room, board, and tuition that we're providing, when I think about the resources we're putting in for our programs, 36 programs in our case, of 850 student athletes, I would say that, boy, that should be enough moving forward. The millions of dollars that we get from our TV contracts, in which all of our student athletes now participate in, especially with our new Pac-12 networks, the opportunity, the exposure that we garner from playing in NCAA championships, that money's all going back into the student athlete experience. Some could criticize whether it's going to leadership. I get that with our coaching staffs, but we're also putting it into facilities for our student athletes. We're putting it in to feed our student athletes, which now we have more permissive legislation to do that. I'm quickly finding out that our student athletes eat quite a bit, and so that's an expensive endeavor. When we look at the resources and I hear the challenges on the other side, we're taking those resources and putting them back into the experience. There are very few institutions, and we're not one of them, that takes that resource and sometimes puts it over to the other side of campus, to the other academic communities. I know that there'll be greater pressure to do that, but we're not in that position because of our broad offerings.
Well, in this whole discussion about team reform as opposed to team market, also the NCAA is really right at the heart of it. They must have a very busy legal unit there these days. We used to say in labor law that when the amendments, the statute became more comprehensive in 1947, it was the Full Employment Act for labor lawyers, and I sometimes think that some of these changes that we're talking about have produced a situation where there's the Full Employment Act for certainly NCAA lawyers. They must have a very big team there, and I wonder what you see the changes being at the NCAA level since the time that you first came on board.
Well, I have to say that when I went from being the general counsel for the University of Michigan to being the general counsel at the NCAA, several of my colleagues there at Michigan were very concerned I would be bored and would not have enough challenges. Seriously, that would be so much more interesting to be a university counsel. And I actually started the office there. They didn't have an in-house counsel, and I really kind of went along the escalator as the litigation grew in this area. I kept adding people to the staff. So that would be the experience that I had of trying to manage this. And we generally did hire outside counsel to deal with litigation and antitrust litigation. But I saw over and over again the conflict that you have when you're trying to promote the student athlete, trying to get them an education. That's why I went to work at the NCAAs, because I was passionate about these individuals getting their education. I felt the only way we could justify all the money that was coming into intercollegiate athletics was that these kids were getting a good education at the end of it. But the disparity kept growing, and it kept growing along with the proliferation of the channels that need content on cable TV and regular TV. All of those opportunities brought more and more money into the field. Back in 1984, the US Supreme Court threw out the NCAA's ability to decide which teams would appear on a Saturday as football games, and opened up that market. And the money that came in then and has only grown and escalated, I think, is really what's caused the tension here. We always have wanted to have faculty and administration involved in keeping athletics within the educational programs. And I think that that's where we've really fallen apart here, that we don't still have our faculty interested in controlling and maintaining the level that they should within the college sports to keep it on an even keel. Instead, we have this proliferation of lawsuits, which it seemed like every year I had another antitrust challenge, and we incrementally made little changes here and there to give the students more opportunity to share in the bounty that was out there. But there's no way that we could get to the numbers that we've been discussing, what the coaches are receiving in salaries, et cetera. When I first came to the NCAA, they were defending themselves in a case that was called the restricted earnings coaches case, in which the NCAA tried to bring down the costs of paying the lowest level coach in a number of sports, and that was ruled to be in violation of the antitrust law. I personally was not there. I would never have named that the restricted earnings coach. I was like, sue me, please, case. But anyway, but the idea was we're trying to bring the costs down, and the reason you keep trying to do that is you want the smaller programs that don't have the wealth that Stanford has to still be able to compete. And you want the concept of the level playing field and competitive balance, sort of the mantra that you hear over and over at the NCAA. And so you want to have rules that allow a program like where I now am at the University of New Mexico to still participate meaningfully in championships with a program like Stanford, which has the ability and the wealth to bring in a lot of very talented student athletes. And it's a question at the end of the day, do these restraints, are they reasonable or unreasonable, which are terms used in antitrust law, to produce the product of intercollegiate athletics. And that was one of the things we continually were trying to say is, these are reasonable to create this product. But the product's changed. It's different than it was. It's not what it was back in when you were all undergraduates. It's a different world out there.
Should there be a minor league, for instance, sponsored by the NFL or the NBA, which would say to some of the players, okay, this is the route you want to go. We ought to channel you there rather than try to fit you within the student-athlete framework.
I'm going to turn to Mike, who really wants to speak here about what it is to be in a minor league program in a sport. I don't know if that's really what we want for our colleges. I mean, originally, you started with the NCAA. The concept was, you know, the classic Greek model adopted by the British universities, which we aped here in America, these were scholar athletes, you know, and it's, you know, mens sana and corpus sanos, healthy mind and healthy body, that they were supposed to meld together. The purest form of a gentleman was supposed to be that balance between the two. Of course, then we brought in a very democratic movement of bringing in people that were not gentlemen only to participate, and people got involved who needed money. We brought in people that otherwise would not have been able to participate in higher education but for getting a college scholarship as an athlete, and that changed the whole dimension. And we really have not caught up with that. But I'm going to turn to you to let you talk about, should we have minor league colleges,
frankly,
sports?
I don't think many people would be interested in a minor league, you know, NFL or a minor league NBA. People aren't all that interested in minor league baseball, except for some of the sideshows that go on more than the game. But I don't think people are drawn to collegiate athletics purely by the talent. If the same talent was taken away from Stanford and made, you know, the Palo Alto so-and-sos, that wouldn't get the following that it gets. People want to root for their alma mater. They want to see, you know, the rivals go at it. And
with the players, if some of these players began to get maybe more than Bernard Muir is willing to concede in this O'Bannon case, do you think that that would have an effect on the spectators? Would they say, oh, you know, I'm not as enthusiastic about coming to see Stanford play Oregon State now that I know that they're being paid as professionals?
I personally feel that way. And from my perspective as a student athlete, I just think it would be very disappointing for the student-athlete community to feel like these couple of sports are not kind of part of this unit that you feel like you're in as a student-athlete. I mean, I loved being a student-athlete at Stanford. The way I could represent Stanford was by pitching a baseball. But equally important, somebody could represent Stanford by being a really fast swimmer or being, you know, great at water polo or being a great tennis player. And it just felt like such a nice community that we each had our own skill, and it allowed us to put Stanford on the front of our jersey. And I think if you start separating sports into, you know, revenue producing versus not revenue producing, you're really going to lose that feel. And if you lose it within the community, maybe you lose it with the fan base too. And, you know, I think there's a whole host of other problems. Does the top tennis player, does he or she get to, you know, negotiate a price to come play tennis at Stanford even though tennis might not earn any revenue? Or does the 80th guy on the football roster automatically get some of the football revenue even if he's never played a snap? And we've got
What about the walk-ons?
The walk-ons. I think we've got an NCAA champion track athlete who's not getting paid, but the 80th football player on the roster is getting paid because he has the good fortune of representing Stanford in a football capacity. I just think it would really change the spirit of Stanford athletics in particular, which is what I can speak about. But the way it should be at colleges all around, it should be a feeling that I'm representing my university, I'm here as a student, I get this privilege to be an athlete as well, and I think that would start to really shift.
You know, one of the great things about intercollegiate athletics is the way it unites the community. You know, on a Saturday afternoon, you get people from the staff, the faculty, the students there, supporting it, and that's really a beautiful thing. And there's not very many places on campus where you get that, and I think it would be changed.
Leonard, you brought some of this litigation that's caused all this trouble and brought us here today. What do you have to say?
Yeah, what were you thinking?
You know, I agree that if you pay Johnny Manziel last year, superstar college quarterback, millions of dollars, people are going to start resenting him and resenting that, and it's not a good thing for college athletics. On the flip side of that, last year's tournament MVP for the NCAA basketball tournament, Shabazz Napier, I believe his name was, after he won the Most Valuable Player award, said he goes to bed hungry at night. Why? So we draw this line, and do we need to draw the line at them getting $2 million or a kid not getting enough food? Our lawsuits have always been designed to push it over to some more reasonable world where a kid gets enough food to eat, and they weren't. I mean, literally, they weren't. And so I think that's a problem. So while I agree with a lot of what's being said up here, I think we need to look at what the rules are for the NCAA and see whether or not we agree with those rules or whether or not those rules are good things. And unfortunately, we had to go through the litigation process to start that process. I'll give you an example. One of our cases, we call it the grant and aid case. A school reports to the federal government how much it costs to attend that school every year. Let's say it's $65,000. Room, board, tuition, a phone to call 911, to go out and eat, movies, that sort of thing, about $65,000 a year. The scholarship cap is below that amount reported to the federal government. So the scholarship cap might be $63,000 or $62,000. Why? That's what the school says it costs to go to school. Why isn't it $65,000? So we sued them. So I think I agree with a lot that's being said, but we really need to look at these rules and ask ourselves whether we're helping the students, helping coaches, Nick Saban making $7 million, and what are our goals? Our goals have a really good football team, a really good basketball team, or to graduate student athletes. I don't think it's to graduate student athletes, not right now at least.
Because just a few years ago, we had rules, we were talking about this on stage, which precluded universities from giving more than a year scholarship, I guess on the ground that, hey, you know, maybe we can find somebody a little better than Mike Gosling next year, or maybe he'll get hurt and we'll give it to somebody else. That the NCAA just discontinued just 2 or 3 years ago. Not too many universities offer multi-year contracts. I think the big thing that's really brought us, one of the big things that's brought us here today is the big spending in athletics, what some people refer to as the arms race in a number of the sports, maybe beyond even the ones that get all the attention, basketball and football. Is it possible to rein in the arms race? Is that an answer to, or one of the answers that we ought to be looking at in connection with the flurry of litigation and the publicity that's been received? And I guess I'll begin with Debra, since Debra hasn't had a chance to say much.
Sure.
Say anything at all.
Well, now I'll make up for it. Clearly, there's a huge amount of money in college sports these days, and every time a conference renegotiates their media contract, there's more money flowing into the system. So actually, the schools that have had not had a renegotiation of their contract for a while are actually, in some ways, you could say, at a disadvantage financially. But clearly, there is a lot of money flowing through the system. And actually, I just recently learned from Paul Tagliabue, who was the commissioner of the NFL, that there actually is a federal law that provides a monopoly for college football to have Friday nights on TV broadcasts and Saturdays.
And what's wrong with that?
So I'd be happy to get rid of Friday nights myself, but and maybe that would really reduce the amount of money. But the NFL can only, they have Sunday and miscellaneous other nights, but they can't broadcast on Friday and Saturday. So it's interesting that the law in some ways has set up these monopolies, which then provide a lot of money into the system. At the same time, there are antitrust laws that prevent agreements to limit, for instance, the amount of money that we pay coaches. Personally, I'd be fine with paying coaches less money, right? But we can't agree with others to do that under the law. And schools that just decide I'm not going to pay more than $200,000 to a football coach would soon not be able to get a very good football coach, which wouldn't be fair to the students playing on the team. So I do think the amount of money is a big problem. But given that there's a lot of money flowing into the system, who should get it? Should it be the media companies? Are they worthy of keeping most of the money and only giving a little bit to schools so that we don't get it? That wouldn't be my answer, not surprisingly. So I think part of the problem is what do you do with the money when you get it? And Bernard mentioned an interesting point. So we get a lot of money from broadcast rights. But part of our negotiations at the Pac-12 was that we would also get exposure for our other sports, right? So that we have the Pac-12 network, hopefully you all get it, and you can watch women's soccer and all kinds of great sports as well. We get a lot of money in, but the amount of money that we get in from these broadcast rights is less than 40% of our athletic budget. So we have to supplement that with generous gifts from endowment, from money from the university to support the 36 sports that we have here. And the money never comes back to the university. In fact, sometimes the university has to help subsidize a little bit when the athletic department runs short. So the money does go, as Bernard said, it goes back into supporting the athletes. And I actually, believe it or not, agree with Leonard. I think there were some rules that were wrong and that it was frustrating because it was difficult to get the NCAA to change them where, for instance, a college player on an athletic scholarship, we were limited in how much money we could give him, and if there was another player who was on a financial aid scholarship, we paid him more money because we were paying him the full cost to attend. And it wasn't that we didn't want to, and I'm sure the other school, it wasn't they didn't want to pay the full cost, it's just that we were limited by the rules from doing that. So we've been extremely supportive of a lot of reforms along these lines, and we've been giving multi-year scholarships, for instance. We're supporting and we'll talk about this maybe a little bit later, but now that we can have different rules for some of the conferences, we'd like to see, requirements for providing for post, your career, if you haven't gotten your degree, money to fund you coming back and finishing your degree, and money to pay for any medical expenses you may have from any injuries that you occurred not only while you were here, but in the future. So I think there are ways we can spend this money that will support the people that are important to us, which is our student athletes. And I think we should be mandating that in any way we can legally. One of the things, that there's been a lot of legislation proposed, and I suppose we can solve this problem by going to Congress and asking them to mandate how we can spend our money, but I actually am very afraid of, be careful what you ask for if you ask Congress to tell you how to run your business. So I can't say that I'm really in favor of that, but I do think that we do need more reform within the system to ensure that the money that comes into the system is going fairly to support everyone in the system, and especially student athletes.
Now we mentioned,
I want to, if I can just interrupt one second, of course, lawyers, that's what we do. And we wait, and if the judge doesn't let us, we try to keep talking anyway. Regarding multi-year scholarships, just briefly, this was an issue when I was at the NCAA, and we brought it before our student groups and asked them about it, and actually they were not in favor of the multi-year scholarship because they felt that their teammates would not try as hard to be part of the team and to make the team if they knew they had a guaranteed scholarship for 4 years. Also, those who did not get a scholarship would not have an opportunity, because even if they were very, very good, to get a scholarship because it had already been given away to that other student. So, there's always two sides to these questions. On the thing about money, many, many times at the NCAA, I saw the situation where there were these reforms and things that we're talking about, giving more money to students, but the smaller school programs were the ones that voted against it because they didn't have the budgets that now the ones that you could think of as the Big Five, who've now sort of are the super group within the Division I at the NCAA, now they're making more rules that allow them to spend more money. It was really the smaller schools holding it back, saying, we don't have the funds to be able to give more money for all these various things. But I do truly believe cost of attendance, room and board, tuition, fees, books, and something extra on top of that always makes a lot of sense and was available, should have been available to everybody. Nobody should be going hungry after winning a championship. Something's wrong there.
Or even before.
well, of course, what's fueling the demand for reform is not simply, is of course some players not having enough, but also the sight of the coach at Alabama making almost $7 million a year. Now we know that Stanford, of course, doesn't reveal what its coaches are paid. And there's a big controversy, the big contrast with public universities. But Bernard, do you think that the payments that do go to non-playing, to personnel, coaches, after all, some of the assistant coaches do very well also under the system. Is this part of the arms race that should be controlled?
Absolutely, it's part of the arms race in terms of trying to control it. It's very difficult. You know, if you're sitting at one of those institutions where coaches are getting paid significantly higher than the norm, you take the risk. If you're the president or the board or the athletic director, by letting that coach go somewhere else where they will pay it, you run a risk. It's funny.
We've done that.
And we've done that. A couple of years ago, as we're marching to the Rose Bowl, people were on. I got a number of emails, love letters from people saying, "You better not lose Coach Shaw. He's being rumored to go to this NFL franchise or this NFL franchise." And I was like, I just got here. I'm having fun. But I understand the demands, and so we try to stay competitive where we think within reason. But there is great pressure. There is an arms race not only on the coaching front, but as we talked about the facility side. We're not going to mirror what everybody else is doing, but we're going to do what's right in our case for Stanford. And that means that we'll spend not thousands of dollars to repair a field hockey field and build a new field hockey field. We're going to spend millions, unfortunately, because that's what the cost is to repair the field. That's what the cost is to have appropriate stands. And by the way, as I was walking over here, we were up 4-0 against Cal. We like that. And but those are not, as I said, not thousands of dollars. We're talking millions. We're investing in sand volleyball. We're investing in our swimming pool. We're investing in our softball complex, our baseball complex, because we want our student athletes to have a good experience, and facilities are a part of that. That's where their learning laboratories, where they spend quite a bit of time when they're not in class and not enjoying all that Stanford has to offer. They're competing, they're preparing to compete. And so we try to provide them with adequate facilities moving forward. So yes, and sometimes our peers really get caught up in this. There are some places that I know have now put in barber shops and other things, leather couches, nice leather couches. And we're just trying to find the things that we think are appropriate in order for our kids to have a good experience and be able to compete.
I have to add in here too that when I was at the NCAA, almost every year someone said, well, why don't you go and seek an antitrust exemption like baseball has for the NCAA so you can finally regulate all this money and what's being paid to everyone? And we did actually pursue with some research, you know, what it might take, what we would have to do. And every time we looked into it, we came back to the same conclusion, that we really couldn't make the case. In other words, it's like, we can't restrain ourselves, we can't help ourselves, we have to give away all this money to all these people. Help us, you know, keep us from giving away all this money to our coaches. And that's not going to be enough for Congress to think to give you an exemption, that you can't control yourself. You just feel you have to pay that much money. So, you know, hey, again, remember, it's us, it's the schools, it's the universities that have to control themselves and decide what they're going to do individually, decide where they're going to draw the line. If they feel they can't do that themselves, the Congress is not going to jump in. As you said a little earlier, the last thing you want to do is invite Congress in to start regulating us.
We got today really and this has been alluded to, kind of a two-tier system in the world of college athletics. We've got the Big Five power conferences. One of those conferences is the Pac-12, which Stanford University is part of, and those conferences kind of live in a different world from the rest of the world. Now, one of the concerns that and I want to come back to Bernard on the new changes that are going to be coming forward in January as they relate to the power conferences. But one of the concerns, of course, is that we've been talking about principally football and basketball. People are saying, well, this is going to create problems for Title IX, for women's sports. People are saying that baseball which Mike was part of the Stanford baseball program. Baseball is a non-revenue producing sport compared to these other ones that we're talking about. You know, professional sports antedate college sports in baseball. That's the only one of the major sports where that is true. And they kind of took the oxygen, perhaps, out of college sports. And I wonder how you feel, Mike, about what will happen to baseball, a non-revenue producing sport, under any of these scenarios. Should we, if we have reforms, if we have the status quo, how do you feel about the non-revenue producing sports?
Yeah, I don't think it's just baseball. I think it's a lot of the non-revenue producing sports. And
Well, we're talking about baseball because, you know, it's really God's game.
It is. The kind of investments Bernard was talking about is the reason that Stanford has the best collegiate athletic program in the country year after year, because they put that kind of money into the field hockey program and the other programs. And that's partly why I'm such a huge Stanford fan as an alum, is because I love the broad range of sports and the success in the different sports. I think that's terrific. The problems I see would be when a school like Alabama takes the $7 million and gives it to the head coach, and where those leather couches in that barbershop are reserved for the football team and the basketball team. You know, players who already have full scholarships, and even if they're going to bed hungry, which is obviously awful, I'm sure there are players in the small sports who have the same predicament, and on top of that have a 1/4 scholarship instead of a full scholarship. So, as you can probably gather from kind of everything I've said here, I like to view these athletic departments as one unit, and let's work on improving the situation for everybody. I'm not in favor of the NCAA lining its pockets. I'm not in favor of the universities not getting all this money that can come their way through the TV contracts and everything else. But I don't think that the sports that happen to generate revenue in an amateur model should be the only sports to benefit from it. I like all of the reforms that Leonard's been talking about. I just want to see them athletic program wide instead of taking a full scholarship and tacking another $5,000 onto that and ignoring the fact that the baseball team has 25 guys splitting up 11 scholarships. That, to me, is the inequity that I would worry about. And actually, I think there's a trickle-down effect, as I mentioned in my kind of first remark, that you could see with younger kids. I think if we get to a point where college football players and basketball players are getting full scholarships, money on top of full scholarships, licensing revenue for the video games, you get to a free agent type system where they're getting a salary on top of that, it'd be a shame to see every good 14-year-old athlete in the country say, I'm going to football and basketball, that's where the money is. How many good athletes in other sports would we lose who would focus on football and basketball and not follow, you know, their natural passion to run track where they can't get
Of course,
a
in some measure, it's said that that is what is happening now under the existing system. We're losing, you know, a lot of good baseball players, for instance, to these other sports. Now, in January, I think Bernard is going to participate in this meeting where I think a decision has been made, or people, the newspapers report a decision to provide more money to the football and basketball players in the Power Big Five conferences that we've talked about. They will change the rules, apparently, at least they're talking about changing the rules about the way in which they can have contact with people who may want to represent them to go into professional sports later. How do you see this developing, and do you favor it?
I think there's more discussion to be had. I think this, like I mentioned, the cost of attendance, I think that will get passed just based on the tenor of my peers out there. These other issues as it relates to student athletes, trying to understand what their value might be to move on to the professional leagues. I think they'll be liberalized those rules as it relates to student athletes interacting with agents. I think there'll be more discussion about that. What parameters do you put on that? But I certainly think higher ed understands that we need to do more for the student athletes where we can. Hopefully you'll see further measures, as you mentioned earlier, about their care, especially as it relates to concussions and health care. I know the Pac-12 the CEOs are going to meet this weekend, and they're going to talk further about what we can do to enhance that, especially after a student athlete completes their eligibility and they leave school, that we can still cover expenses for them as it relates to injuries that occurred while they were in school. So I think you'll see more student athlete reforms coming. I think that's a good measure, but how far do we go? It remains to be seen, and that's where the pressures just continue to mount. The one thing that the judge ruled on was football and men's basketball players should be entitled to additional resources, but the judge did not give us clarification about the implications from a Title IX standpoint. We all assume that has to come into play. That's additional resources that we need to provide. We get it, but again, we have to think about where those resources are coming from.
For more, please visit us at stanford.edu.